Okay, morena everyone. We will start day 2 of hearing 14 with a karakia. Whakataka te hau ki te uru, whakataka te hau ki te tonga. Kia mā kinakina ki uta, kia mā karata ki tai. Kia he api ana te apakura, he tio, he poka, he hauhu, ki he moriora.
Kia ora.
Tēnā koutou katoa, welcome back everybody. Day 2, hearing 14. We were scheduled to hear from the Roman Catholic Bishop of the Diocese of Auckland. They are not going to be presenting evidence today, and we've got their written evidence. So we will move on to foodstuffs and McDonald's. Mr. Badham, you're there. We're here representing both applicants, but we're going to hear your foodstuffs North Island Limited evidence first.
Yes.
I assume you have a PowerPoint presentation to show us as normal. Is that correct?
Yes, sir, I do. And yeah, so we'll go to foodstuffs first and into McDonald's. But there is a lot of similarity, as you'll observe in my evidence, between the two. So some of what I talk about in foodstuffs is duplicated in McDonald's. So it might be that that conversation is a bit shorter for the second submitter.
Well, I can tell you that we've got plenty of time today, so feel free to take your time. And I understand you've got with you Ms. Alicia Lowry. Is that right?
Yes. Alicia's online. You're very familiar with who I am, but so I'll let Alicia introduce herself.
Yes. Yeah.
Kia ora koutou. Morning. So I'm Alicia Lowry, and I am an urban designer with Barker & Associates based in Wellington. So prior to moving to Wellington, I was based in the Whangarei office with David. So I've been with Barker & Associates for 3.5 years, coming up to 4. And prior to that, I was based at Whangarei District Council as their urban designer, primarily working with the strategic planning team, but also worked with the resource consents team as well as the policy planners there. So I grew up in Whangarei. I have lived there for most of my childhood, and just recently moved back to Wellington. Good to meet you all.
Me too. Okay, Mr. Badham, we'll hand it over to you.
Okay, thank you, sir. So yes, thank you for having me again today. As a custom, I do have a PowerPoint presentation which I'll work through, which just summarises Alicia and I's evidence as it relates to foodstuffs submission points that we addressed. So there are a couple. First, okay, so I'll go through in this order. First and foremost, just the zoning framework. So I had some comments in my evidence regarding that. Then I'll talk about the definitions and nesting tables and focus on the provisions for supermarkets in the mixed use zone, because that's the primary focus of my evidence. And then pedestrian frontages and verandas, which I'll pass at that point over to Alicia to have a talk to that from an urban design perspective. And then I've just got a follow-up slide just with some summary and key takeaways. As I've done throughout the hearing process for the final district plan, if you've got any questions or comments as I'm going through the presentation, please interject. I'm happy to talk and take them as we go, or otherwise at the end we've got a chance for further questions as needed. So first and foremost, the zoning framework. I won't spend too much time on this because obviously there's been quite a bit of movement on this, and I acknowledge the evidence of Mr. Lindenberg from council and also Ms. Trinder in terms of the recommendation to include a town centre zone in the Kerikeri area due to the finding that it's an urban environment under the MPSUD. So I support that. Something I had outlined and sought in hearing 1 for evidence for a number of submitters. So I think that's a good move and a commendable one. The issue I think that presents, and it is picked up in the Section 42A report, is that it's proposed, but we don't know actually the spatial extent of it or what provisions are going to apply. So it does create uncertainty for foodstuffs and other submitters. In terms of, well, actually, is their site going to be in the mixed use zone or is it going to be in the town centre zone? That's particularly relevant for foodstuffs in this instance because they have a New World store in Kerikeri, in the centre of Kerikeri, and we don't know currently whether it's going to be in or out. So it's something that I think, ultimately Foodstuffs didn't opt in to the opt-in process for rezoning evidence for 15D. Now that we have essentially deferred the town centre zone and the provisions to 15D, it's really just a heads up to the panel that Foodstuffs will be interested in looking to review and attend and present evidence on that matter. Just in a broader sense, I think, and this comes through my evidence, but it's also a bit of a theme as to why I've made some of the points I've made, is the Far North District Plan is quite novel in my view, that it's got a single mixed-use zone, which is the one commercial zone, notwithstanding the recommendation for a town centre zone, applied across the entire district. And in my mind, that's creating some tension in an activity-based plan. Essentially, you've got a mixed-use zone, which is trying to be everything in multiple different types of urban areas. So from Kerikeri to Kaikoui to Paihia to Kaitaia. And you don't have a lot of tools in the toolbox for zoning currently within the plan, which I think is leading ultimately down towards more restrictive consenting requirements, because the mixed-use zone is trying to, I guess, do everything in every place. So that's just really an observation for me. There's no actual recommended changes I'm saying there. I support the status. They recommend the acceptance that it's a Tier 3 status for Kerikeri Waipapa, and Foodstuffs will attend hearing 15D as and when we get some more details on what is in the town centre zone provisions. One of the other key topics I address in my evidence is definitions and nesting tables. So this is something that was picked up early on in our evidence. So I presented evidence at hearing 1 on the strategic direction and other matters. Now, obviously, throughout the hearing process, it has sort of pivoted a little bit, and a number of the definitions relevant to a certain topic have been picked up and addressed by the council in that relevant hearing. I think that there's still a question mark in my mind about nesting tables and how they are used. And I think this really comes home, it really hits home when you look at the mixed use zone chapter and some of the submission points that Foodstuffs and others are making as it relates to activities, because you have the situation where without nesting tables, in my view, you have multiple activity definitions that an activity such as a supermarket could apply under. It could be a commercial activity, it could be a retail activity, it can also be a supermarket. And then you have objectives and policies, which at a high level refer to the provision of commercial activities, retail activities, but then not the supermarkets. Now, this will come when I talk further about the policy direction in the mixed use zone for supermarkets, but I think there is a real case to be made for using nesting tables here. It's an effective way that you can use terms interchangeably throughout a plan to reference to multiple subcategories of activities. And I think that's a really important thing to look at and include in a plan such as this, where you're going for an activities-based approach, but then you also have effects-based provisions. So just to clarify that in terms of Foodstuffs, they're happy with the acceptance of the definition of supermarket. That was accepted, so that's good. But I do think that nesting tables would be very beneficial to providing clarity and consistency of interpretation of key activity types for plan users. So council can see it as a decision-making authority, but also for users of the plan. On this next slide here, I've just got an example of a nesting table from the Whangarei District Plan. And this is what I'm talking about. So you've clearly got here commercial activities, but then under that, you've got the subcategory of a retail activity. In this instance, so if you're looking at it specifically for Foodstuffs, now in the Whangarei District Plan, they defined a grocery store rather than a supermarket. In my mind, whether it's called a grocery store or a supermarket it's relatively irrelevant, doesn't make a big difference. But you can see the benefit there. Now, if you look at the actual provisions in the mixed use zone, you've got a number of objectives and policies which refer to, say, for instance, commercial activities. Based on if you include a nesting table and you refer to commercial activities in a policy or an objective, then it is quite clear that you are also then referring to a retail activity and a supermarket. And in my opinion, and experience, that's incredibly helpful, because in what you find is you're going to get a lot of, and this is what reviewing foodstuff submission as it relates to one of the policies which I'll come to, is they're seeking that, well, we want to have provision for supermarket, but if you make it abundantly clear that a supermarket is a commercial activity via a nesting table, then you don't need to do that. It's actually clearly spelled out, and in my opinion would be very helpful for the plan in a whole in terms of interpretation and consistent application of activity-based definitions. I'm just going to pause there and just check in with the panel to see if there's any questions or comments on those two first points that I've made.
Thank you. Do you have any questions?
No, not really a question, David. It's an interesting approach. Obviously, it's something that we need to, think more about. So we'll just receive the evidence you provide.
I mean, interestingly enough, supermarket's not listed as a retail activity in that example you provided.
So it's listed as grocery store. That's that point I was making, sir, about how in the Whangarei District Plan they have defined grocery store. So can you see my cursor?
Yeah, that's interesting that it's included under a category trade retail. Anyway,
yeah, so
that's
they've gone commercial activities. Yeah, so commercial activities, retail activity, trade retail, drive-through facilities, general retail, grocery stores, and then they've got other subcategories of it. So you see nesting tables in quite a few second-generation plans around the country, and in my opinion, applying these in a resource consenting basis, when you're actually looking at activities and provisions, it's incredibly helpful, especially when you're. Sorry, carry on, sir.
Are you saying your supermarket would come under grocery store?
Yeah, yes, it would. So essentially, Whangarei District Council in this instance, and I was involved in the Whangarei District Plan, they decided to define a grocery store, and it's essentially the same as a supermarket rather than calling it a supermarket. So that was just a term, because there's not, as I understand it, there's not a national policy, national planning standards definition for supermarket or grocery store. Foodstuffs in its submission on the Far North District Plan sought supermarket, but essentially the equivalent of that in the Whangarei District Plan is grocery store.
Yeah, I just find it almost amusing that you call the supermarket a grocery store. Sounds a bit like that TV program with Arkwright the grocer.
Yeah. So it's a bit like I would personally refer to it as a supermarket in my mind, but in that end, that's just where they've ended up. So, but yeah, it's just. I think the key there, and there are a number of other examples of this. I've just shown you the commercial activities one, but I do mention it in my evidence that you do the same thing for residential activity. So you then say residential activity, and you have retirement village or residential unit, and you have all of those definitions subcategorized underneath it. Another good one is industrial activity or community activity or civic activity. And it just provides, when you have a plan which has a number of activity-based provisions, so objectives and policies, but then also rules, it makes it clear, in my opinion, what you mean when you refer to commercial activities in a policy. It actually means all of those things as well.
I suppose the only comment I got, and thank you, because I was thinking, what was on the tip of my tongue before you showed that slide was provide us with an example. So thanks. That's an example of how you would structure. I suppose what I'm thinking about is, if you do it for the commercial zones, well, if you do it for one group of zones, you probably want to do it for the entire plan, wouldn't you? That would be my advice. And you wouldn't do it for every activity, but there are key activities that you use interchangeably throughout a plan where this is incredibly helpful. So the examples I gave in my evidence would be commercial activities, industrial activities, residential activities, and commercial, I think I say civic or civic activities, or community activities or facilities. Because generally in a policy or an objective, you want to use the broadest term if you're referring to all of those activities, rather than listing out for everything commercial activities, including retail activities, including commercial services, including food and beverage. It's actually helpful from a plan usability and consistency perspective. And it's something that foodstuffs and other submitters that I've worked on behalf have made in their submissions, is that actually these nesting tables are not only helpful for council in terms of clearly articulating what applies to and what activities, but they're incredibly helpful for plan users as well. Because when you're looking at a objective, like a good example would be
one that I've zeroed in on. Okay, so let's look at MUS P1. It says enable a range of commercial, community, civic and residential activities in the mixed use zone where explaining as an ABC. Now, if you had this, you would know what the commercial activities you're actually referring to. And the thing is, for a supermarket, so we've included a definition of a supermarket. A supermarket can meet multiple definitions. A supermarket's a supermarket, but a supermarket is also a retail activity. A supermarket is also a commercial activity. And where this becomes particularly key, and I'll come to it as well, is when you have different activity-based rules, say for instance, large format retail. So as a supermarket, both a supermarket and large format retail, I would argue that a supermarket is a retail activity, and then you've got this in the large format retail, you've got a 450 square metre limit baked into the definition, whereas it's actually a retail activity, and it's also a supermarket. But if you have a nesting table, it is clear for all what when you're using those terms. If you use the broadest term, commercial activity, you mean all of these. Now, this is obviously the Whangarei District Plan example. You would need to apply some nuance based on what's in the Far North District Plan, but I think it paints a picture of what Foodstuffs and others are thinking and what I've outlined in my evidence.
Yeah, okay. So, but it seems to me that the implication is that if you do this, this is a plan-wide structural suggestion, and it seems to me that you wouldn't just do it for one nest of zones. If you did it for one, you'd have to do it for the whole plan, I think.
Correct. So the reason I raised this in my evidence, because I've observed this happening where you have specific definitions being addressed, sort of picked up in each one. So for instance, in the infrastructure hearing, we had definitions related to infrastructure address, and no problem there. But when you're starting to get into activity-based definitions, I think you do need to apply a wider lens across the plan, because obviously if we include and change definitions, that has implications on other chapters of the plan. So the Foodstuffs and others have made the submission point. I know that there was in the original hearing program, a suggestion that this would be addressed in the last hearing. I can't remember the numbers. I think I had it in the previous slide. But you can see when you're dealing with provisions on a zone basis here, and especially in an activity-based plan, the complications this creates. So to answer your question, I would say that yes, the council should consider, and the panel should consider this on a wider basis and observe the benefits that could eventuate, or that would eventuate, in my opinion, if you included nesting tables of key definitions.
Yeah, okay. I think obviously the question is the complexity of activities in the Far North justifying that approach? Obviously, you're clearly saying yes. We'll hear from council officers about that later on today. And this sort of brings me to another point about you saying that the mixed use zone is trying to do a lot of things, and acknowledging your support for the town centre zone, notwithstanding we're not sure what those provisions will say or where it's going. And I was just sort of thinking about this whole question of the mixed use zone is doing a lot of things, and I'm wondering whether that's because of the nature of the Far North and its communities. I mean, the Far North isn't like Whangarei. It's not no major city. We're here in Kerikeri with a population of just over 10,000, depending on how you measure it. And that's clearly its largest community. And I'm thinking about the central areas or commercial areas of all of the communities, the individual communities that are there. Isn't that sort of reflective of a mixed use zone type of arrangement, that they are a mix of activities? They aren't clearly commercial in some areas. Maybe you could make that argument for Kerikeri, maybe for Kaitaia, possibly Kaikoa, but in terms of all the other areas, that really is a mixed type of environment, isn't it?
So I do address this in my evidence briefly, because it refers back to hearing one. If you look at section 4.3 paragraph 4.3, I do touch on this and say, so for instance, I'm quite familiar with Far North District, so the two areas that I would touch on immediately would be Kaikoi and Kaitaia. So in those areas, now this might not be the application of a town centre zone, but I think there is a strong case of using another zone in the toolkit, which if you looked at the national planning standards, would be, for instance, a local centre zone. So, for instance, a local centre zone.
Saying that in addition to the town centre zone or instead of the town centre zone?
Well, so if the town centre zone is to be applied to Kerikeri Waipapa, I think you could make an argument that a town centre zone could also be applied to Kaikoi and Kaitaia. But if you wanted to create a hierarchy of centres to say that Kerikeri is the town centre of the north, then you could look at Kaikoi and you could look at Kaitaia and look at them as a local centre zone. Because actually, in my opinion, if you look at, say, let's take Kaikoi for an instance, the actual central urban area is predominantly commercial activities. I don't observe a large amount of residential activities along the main street or in the areas around it. So in my opinion, you could apply a local centre zone, and then because I see that the mixed use zone, how bluntly it's been applied across the Far North District, I say on those three particular centres, Kerikeri, Kaitaia and Kaikoi, has resulted in these provisions which are quite restrictive because they're trying to do multiple things. I'm not questioning, say, like for instance, Paihia or some of the other smaller applications of the mixed use zone that you do see. But it is something that I think, and this is something I picked up, and I mentioned it in my evidence here. It's something that we picked up and sort of canvassed in hearing one as well, in terms of the lack of a centres hierarchy and a centres hierarchy, but the application of other zones. So I think an argument could be made that if you're not going to apply the town centre zone to Kaitaia and Kaikoi, there is another zone that you could apply there, e.g. a local centre zone, which will provide some more nuance, and you're not ending up with a situation where it's trying to do everything across the board, if that makes sense. That's my high level point on the zoning framework.
What's the intention of all that, David? Apart from introducing a lot of confusion to the district plan, what's the intention of it? Is it just to provide better for supermarkets?
So ultimately for foodstuffs, in the scope of their submission, they would say ultimately if you have if supermarkets are enabled, they'll be happy. So they'll put that to one side, and I'm sort of, this is the point I made on behalf of a number of submitters, but the part of the problem you're getting is that you have the mixed use zone applied so broadly across the district to so many areas that it's creating this tension in my mind in terms of the actual rules that come out in terms of restrictions on supermarkets. So that there is, and I haven't addressed it in any great length in this evidence because obviously we're focusing primarily on the mixed use zone. But I think that some of the issues you're having or that you're observing that submitters are raising is related to that point, is that you only have a single zone.
Yeah, I mean, I suppose what we're going to be wrestling with is the actual nature of commercial areas in this district, noting that the communities are quite small. Whether a hierarchy of more than two zones is actually justified. Having said that, we get to see the actual provisions of the town centre zone, and they can be tweaked.
Exactly.
And you may be able to kill two birds with one stone.
Possibly.
In that, I mean, just because it has town centre zone in its name doesn't mean it's reflective of a town centre zone you would see in Auckland or Whangarei.
No.
Could actually reflect some of those neighbourhood. I suppose what we want to ensure is that the hierarchy of commercial zones reflects the nature of commercial activities in the far north. And to play devil's advocate, we don't want to create a situation where we've created a hierarchy to certain supermarket industry. But not needed.
No. So to be clear, that's not what I'm suggesting either. This is a high level point I'm making, is that, and so like for instance, we've settled on a town centre zone and a mixed use zone. Currently, the town centre zone has been signalled to apply to Kerikeri, but then the question I would ask is, well, what assessment and what consideration has been given to whether a town centre zone should also apply to Kaikoui or Kaitaia. Those would be the two other centres in the far north, which I would say warrants some consideration. It could be that you elect to say there is only two zones. It's a town centre zone and a mixed use zone. And you could, to use your term, kill two birds with one stone and consider those areas as well, based on whether they also are town centres, rather than introducing another complicated zone in terms of a local centre zone. That was just the point I was making in terms of the, the sort of broad application of the mixed use zone.
No, thank you for that explanation. I might just ask the council officers, and I'm happy for you to keep your powder dry if you'd rather, but is the council contemplating applying the new town centre zone to other commercial areas other than Kerikeri?
Might start in front of it and probably defer to Stringo. Sorry, my apologies. In principle, we do agree that there's perhaps less regularity than is desirable, but really we think that's probably more in the LFR space for Waipapa. Yes. We've signalled that in the report at this stage. We'll also note that there are community aspirations for these town centres about what they are and what they might be and what activities they might want to have, irrespective of the submitter's desire to have permitted activity in supermarkets in those areas. So that will introduce an inherent conflict that we've tried to manage in that. And I think for some of the concerns we had initially was when we spoke, probably here in one, I think, was trying to manage the reverse sensitivity effects in those zones. So it's not about simply having all activities in there permitted. It's also about trying to maintain the aspirations or have the aspirations of the community provided for as well. And so I acknowledge that because of that, there might be a slightly higher or perceived, more conservative approach to managing those sites and areas, right? But
I think that's what I was sort of getting at when I sort of said, you've chosen a mixed use zone because there's mixed use character, because that's literally, that could be how you would describe a number of these commercial areas, because they are small and mixed use in character, and they are doing multiple things. Okay. So, Mr. Turner, have you got something to add? I mean,
can we just back up to what LFR stands for?
large format retail, big box.
Big box. Normally. So, I mean, I suppose the question is, are you contemplating potentially applying this zone to other commercial areas?
Sounds like
Not at this stage. No, we've got the most information about Kerikeri right from the town centres over there.
Not at this stage. Okay. I mean, there's no wrong answer. I just wanted to know. Okay. Well,
just following off from your great question here, and the point about possibly considering the town centre zone. Where Pack and Save is located in Kaitaia now, some people, including the communities the community in Kaitaia that participated in the market, consider that to be outside of what they've identified as a, I don't think they call it a town centre zone, but in the spatial plan, not spatial, the master plan that they created, that site would be outside of what would probably be classed as a town centre zone. Have you seen that master plan for Kaitaia?
No, I haven't. I have not seen the master plan.
The old location would be included in the town centre zone. And if we didn't address town centre zones through this proposed district plan process, can you see us, how can you see us addressing that, what is your wording, the issue of the multiple zones across a large area? What other means would you see that being addressed?
So just to clarify, do you mean what other means in this plan process or in a future plan process?
Outside of this proposed district plan process. Yeah, being through a plan change which we're a bit uncertain
Right.
about.
Right. Oh, look, so currently you're in this plan process. You're looking at it district wide. Obviously, very conscious of the government changes in direction in terms of the RMA replacement. Far North District Council and other councils will be going into the combined spatial strategies and combined plans as well. So that, and my understanding of that is that that's going to be coming up in a couple of years. So to an extent, this is all going to be revisited under that, but also on a regional basis. So if I was to put it bluntly, there'll be another bite at the apple in a couple of years probably on this entire stuff, all of these matters.
Thanks very much.
Okay.
Thank you for answering those questions, and thank you to council officers. We'll come back to you, Mr. Adam. I'll let you continue.
Yes. So look, I'll just note one thing. I did struggle to hear what Ms. Trinder was saying. It was quite quiet. I did hear Mr. Witham quite well. So just maybe future, it just that was a bit quiet. So I didn't quite catch that bit.
But you did hear. Well, I sort of repeated her conclusion, which is.
Yeah, I think so. Yeah, so I think we're fine there. I'll carry on. Okay, so the mixed use zone. So this is the policy direction for supermarkets in the mixed use zone. So Foodstuffs saw changes for a new policy to support supermarkets. It was rejected. And then I was just making the point in my evidence that you kind of got this situation now where there's a new permitted activity rule inserted, and you have got a policy which talks about commercial activities. But again, this is my point about this is a good case study example of why I think nesting tables would be helpful. Is there's actually a lack of policy direction which undermines the coherence between the rule and the broader planning framework. So the change that I had recommended was, well, okay, this is policy MUS P1. This is the one I referred to earlier. So enable a range of commercial, and then I put including supermarkets. But alternatively, if you include nesting tables that explicitly nest retail activities and supermarkets, then I don't actually think that this is needed. So there's a either or recommendation in my mind as it relates to Foodstuffs. If I was to say which one I thought was a better outcome, I think the better outcome would be including nesting tables, because that will cover multiple commercial activities as well. So yeah, that was what I was talking about earlier when I said examples of how commercial, community, civic and residential activities are referred to in objectives and policies, and why nesting tables could be helpful.
So if we didn't go with the nesting tables approach, see that as an alternative of that, having your additional including supermarkets into that policy.
Yes, that was why I put that there as that was essentially the primary relief if you didn't decide to do that. Where I think where these sort of things become complicated is then there might be multiple people, well, maybe not in the submission post, but possibly on appeals, that go, actually, we want to have including supermarkets, including trade retail, including blah, blah, blah. And then you find quite quickly that the directives and policies get quite unwieldy in terms of how long they are. But that would also achieve what I have outlined.
But just following on from Commissioner Watson's question, again, if we weren't favouring a nesting table, would there be a case for looking at the definition of commercial activity and adding to it to specifically say this includes, but not limited to, the following activities, and you could list supermarket specifically in that definition?
Absolutely, and I've seen that happen across other plans, and I would suggest that you would look at that more if you were to recommend that, or if council reporting officers were to do that. I think you need to carefully look at, if you're going to include an inclusion or exclusion list, to carefully look at that across all of the relevant activity definitions, so it's applied correctly and consistently. But yes, that would also work.
Okay, well, I've telegraphed that nicely with council officers for discussion later on today. So great, thank you.
Oh. Okay. And And then, okay, this is just relating to the supermarkets provisions. So essentially, food staff sought changes to MUS Rule 1 to enable large supermarkets and avoid unnecessary consenting for minor building additions. So the reporting officer has introduced a new permitted rule for supermarkets, MUS Rule XX, and it includes a 450 square metre GFA limit without clear justification, in my view. There is, it's sort of outlined in my evidence, talks about how there's a justification for restricted discretionary activity status. And I make the point, and I'll talk to this in more detail in the next slide, about how it overlaps with existing, well, in my opinion, the matters of discretion overlap quite significantly with the existing provisions that are already in the plan. And in my opinion, it leads to unnecessary duplication and inefficiency. There's also another point I make here in the conflict that exists between MUS Rule XX and MUS Rule 14. So MUS Rule 14 is the large format retail rule, which says large format retail is a discretionary activity. Now, again, the definition of large format retail includes a 450 square metre limit in the definition. In MUS Rule XX, you have a 450 square metre limit, and then if you're not, it's supposed to become restricted discretionary. Now, I see that inherently as a conflict, because if the intention is for, under the reporting officer's opinion, that you should go to a restricted discretionary if you're over 450 square metres, but then you have a rule later on down which says large format retail is over 450 square metres is discretionary, we've got a conflict there. You've got two rules essentially saying one's restricted discretionary and one's discretionary. And again, without the clear application of definitions and rules, I think that will lead to confusion. So I'm just going to take you through my thinking on the next part. So these, sorry,
David, can I just take you back to that 450 squares? You say with the officers without clear justification. I mean, they'll have the opportunity to address this later. Why do you believe they have the 450 square GFA limit?
Sorry, could you repeat that? I just lost you in the last point.
Why would there be the 450 square metre limit on supermarkets?
Why would there? Because there was one point that was made in the 42A was around second generation plans. Other second generation plans have that 450 square metre limit. So I did do a check, and again I looked at the neighbouring plan in Whangarei District Council, where I saw that the 450 square metre limit presented itself was actually in the shopping centre zone, which is a special purpose zone. And if you're familiar with Whangarei, the shopping centre zone is Okara Shopping Centre, so where the Kmart and the warehouses, and they have a 450 square metre limit for retail activities, but it's in the rule, not in the definition. So beyond, in the absence of any justification of it, and this is why I was trying to sort of piece this together in my evidence, I looked at the explanation given, and it said to address adverse effects. And my understanding of adverse effects, given that the reporting officer had recommended a restricted discretionary activity, were the matters that were in the matters of discretion. If you were looking at it broader, I would be speculating. I don't actually know or have any clear justification as to why a 450 square metre limit has been applied. That was sort of the best I could do looking at the information in the 42A and a neighbouring example.
Yeah, maybe if you're looking at the Whangarei plan, maybe it's to try and distinguish them so they don't drift into the large format retail type operation. What are the sizes of the supermarkets you're trying to provide for at the moment through the district plan?
So we did canvass this in the rural settlement zone hearing. Yeah. So in that case, there was also another GFA limit on those. From memory, it might have been 400. I'd have to dig it back up, but there was a GFA limit. So Foodstuffs did actually present some evidence on store types. So in those smaller rural settlements, for instance, they'll be looking at a 4 square. And a 4 square is typically like a standard 4 square is about 600 square metres from memory. But in a mixed use zone, and this is what I was going to at a higher level, because you've got the mixed use zone applied so broadly across the district. Say, for instance, what's appropriate for a supermarket in a larger centre such as Kerikeri versus Kaikoi and Kaitaia, compared to, say, Paihia or some of the smaller communities where you have this, is different. Because in that instance, I would suggest in the smaller communities, you wouldn't want to have a large large supermarket necessarily in the centre. But in a bigger area, it's something that would, in my opinion, reasonably be anticipated and provided for. And you see that in Kerikeri, where you have got a new world. Again, we don't know the spatial extent of the town centre, but you do have a new world, a reasonably large format new world in there. So looking at this just on the face of it, I don't, and how broadly it's been applied, didn't see a clear justification for it. It could be based on, the viability of centres type argument. But again, because you've got such a broad application of the mixed use zone, I'm sitting here going, well, I don't really understand why that's there. What is the purpose and what is that doing?
I think you're probably providing the justification of what you're saying. Because clearly 450 squares from those earlier hearings provides for what's there at the moment. If you were to go bigger, you might be sort of conflicting with the town centre approach or the mixed use approach in those smaller settlements, and maybe an ideal approach to consider. Effects might be justified on that basis, but yeah, I'll leave you to your evidence anyhow. Thanks.
Yeah, so look, I'll go to that restricted discretionary points that I made. So this next table kind of summarizes it. So these are the matters of discretion for supermarkets that don't meet the permitted activity criteria as they relate in the reporting officer's 42A. So essentially you've got 4, the extent of any effect on the transport network, any access, well, essentially access. So again, the point I'm making there is what are we actually addressing here? Because those matters are already addressed, in my opinion, in the transport chapter, and in particular, you've got Tran Rule 5 and overall access requirements. So, in my opinion, there's a double up there. I don't actually see what we're addressing in this restricted discretionary activity consent. Clause C refers to minimises building bulk and signage while having regard to the functional requirements of the activity. Again, you've got the MUS standards, so MUS Standard 1 to MUS Standard 7 and also MUS Standard 10, which have pretty clear limits on that. And then you also have the signage chapter, which limits and restricts signage. And if you don't, for all of these things, if you don't, you trigger at least restricted discretionary and sometimes discretionary consents. And then finally, the last point is landscaping. And again, the MUS standards have quite clear landscaping requirements already. So the point I'm making there is, if it is a restricted discretionary activity, and these are the matters of discretion and the effects that we're concerned about to control if a supermarket is over 450 square metres, then I'd argue that what are we actually addressing beyond what's already addressed in the district plan currently? Just going to pause there. That's to see if you've any questions or comments on that.
I understand where you're coming from my point of view.
Okay, I'll move on. So that's just the recommendation I had. So that's for the supermarkets, but then also in the MUS Rule 14, I've just recommended it includes excluding supermarkets, just to avoid. So that MUS Rule 14 1 is to address the overlap because you have this permitted, restricted, discretionary, and then a discretionary. So that's why I've recommended that. At this point, we come to MUS Standard 5 and MUS Standard 6, which is pedestrian frontages and verandas. So I'll just quickly summarise it and then I'll pass it over to Alicia to talk to it from an urban designer's perspective. But basically, foodstuffs sought an exemption for supermarkets from the pedestrian frontage and veranda requirement. Reporting officer rejected that for supermarkets, citing potential impacts on streetscape and adequacy of the restricted discretionary process. Essentially, foodstuffs have engaged Alicia to provide urban design evidence. I've relied on Alicia's evidence, and therefore I have not proceeded to support the overall point that should be removed. Essentially, Alicia has said that actually there is a basis for it, and I've accepted that and moved on in terms of my professional opinion and evidence on that. But what the one outstanding matter was the actual spatial application of that to the New World in Kerikeri. So at this point, I'm going to stop. I'm going to pass it over to Alicia to carry on talking.
Thank you, David. So as David said, what I was engaged to do was to provide some urban design advice on foodstuffs submissions, particularly in regards to the pedestrian frontage overlay in the mixed use zone. So in my opinion, how council has approached the pedestrian frontages, it's an appropriate response in order to achieve what they're wanting to achieve in terms of active frontage outcomes. So while this is the case where it has been applied to New World Kaikohe, it's not necessary in order to achieve those outcomes. Do you want to jump to the next slide, David? Thank you. So this image is helpful just in terms of talking through the pedestrian frontage overlay that's been applied. So in a lot of the context, including Kaikohe, these have been applied on main commercial streets, so kind of key streets at the centre of the mixed use zone. And where it's expanded beyond that, it's primarily along those secondary streets that stem off of that main street. And this will allow for sort of that consistent active frontage outcomes at key intersections and along these commercial streets as well. So the New World Kaikohe, which is sort of shown by that red outline there, this sort of indicates that the pedestrian frontage overlay is a little bit different. It is sort of isolated from all the other pedestrian frontage overlays. And then on top of that, if you go to the next slide, David. While the other pedestrian frontages are applied to street frontages, commercial street frontages, this one is applied to a car park. So it fronts onto a car park. While in the public road reserve, it definitely reads as a car park that services the New World. And then the other point that I made in my evidence was that it runs through, like partially through the centre of the New World in Kaikohe. So based on that, the recommendation I've made is that this particular pedestrian frontage overlay as it applies to the New World in Kaikohe be deleted. And yeah, happy to hand it back to you guys, hand it back to the panel to take any questions.
No, I think the evidence and evidence, and I think we can make a call on what we heard, I think.
Yeah, I mean, we're up in Kerikeri at the moment, so that's possibly a property that we could visit quite easily while we're up here. So we might give some consideration to having a look at that example. But also too, we'll hear from council officers later on today about the circumstances that relate to that particular property. Thank you. Continue, please.
Thank you.
Okay, thank you. So that's just essentially the recommendation and the evidence is to just remove that overlay as it applies to that part of the site. So it's pretty clear. And look, that's essentially the end. So just to summarise, there's some ongoing concerns about the zoning framework and the lack of clarity around the town centre zone extent. And as I mentioned early on in the presentation, foodstuffs, we'll look at what comes out from council regarding the spatial extent and the provisions and respond as necessary. I feel like we had a good discussion there around definitions and inclusion of nesting tables, and in my opinion, they should be included. And I think they will assist with plan interpretation and consistent application of provisions. Talk through the point around policy support for supermarkets in the MUS, and there's obviously a number of ways that you could skin that cat that we had a bit of a chat about. So that's there. And then finally, the last 2 points, the restricted discretionary requirement for supermarkets, I consider it's unnecessary, and then the matters of discretion in the recommended RD criteria duplicate assessment of requirements that I think are clearly already addressed elsewhere. And then finally, the pedestrian frontage overlay should be removed from the New World site in Kaikohe, and that's relying on Alicia's evidence. That's the end of our presentation. We're happy to take any further questions or comments the panel may have.
Just to make it absolutely clear, you don't have any issue with pedestrian overlay itself or how it applies to any other site, just Kaikohe?
No, it was just that specific site. So where it's been applied elsewhere, I think it is a really good way to achieve good active frontage outcomes in those specific locations where you want to see areas of high glazing and verandas.
Just before we leave the Kaikohe site, and just so, and I suspect we may make a diversion there on our trip back south. It looks like that's is that a public road? Is that a public road that runs from Memorial Drive through to Broadway?
You mean Dickinson Street
Um,
that runs in front of the supermarket?
Yes.
The Merino place.
Merino Place. Is that a public road?
There's a public road, Dickinson Street. that
Dickinson
runs
Street.
along
Yeah,
Broadway
Dickinson.
And comes
Yeah.
parallel to, it runs along the supermarket parking.
I'm using what I call Google Site Visit at the moment. And yeah, so Dickinson runs from it's a public road. It runs from Broadway and it then becomes Merino Place
Yeah.
at some point.
Yeah.
And what Ms. Lowry referred to as a car park, that's actually road reserve, it's a public road, public.
The middle of it's public.
It's public, I
road.
mean, it's
Yeah.
grey on that road.
It's a mixture of private and public space.
Oh, I-
So it is a thoroughfare, so people do drive, it's one-way
Yes,
road, so you only can walk Broadway and come through.
Yeah.
So you do have people using it for that purpose. And also mentioned by you, there's other independent outlets and shops within what they call the Merino Court area. It's also a very common walkway for people as well, because there's if you walk up, you walk past the supermarket, and then you walk past the Merino Court buildings, and then you come into another public walkway area where there's the public toilet. And we walk across the field, yeah, and this is the place. Yeah.
Maybe we should be looking at charging you for the car parking, David.
So, I mean.
No comment.
I mean,
It's used by pedestrians to cut through to the main street.
my question's quite simple. And I thank you, Marie. This is quite simple. It's road reserve, it's a legal road. It is a public land, of which a part of it is formed in public parking, I'm assuming. So does that retail then front a public road?
Theory.
Are you
I think
asking
it's
that
fine.
question to us? Sorry, I'm just
I'm
clarifying. You asking
asking
that question to us?
anybody who wants to answer.
Yeah.
Council goes first.
Yeah, visit the
Yeah.
site, Mr. Chair. I think you have to experience it. I think it's better to experience to understand the function and role of the area.
But it's fronting land that's in public, that's like formed as
I think,
public parking.
I think we have to check to make sure that there isn't any private parking. Should there are exclusive parks from the supermarket, that would indicate to me there is private and public space happening in that area, and we need to come back and definitely identify that.
Sure. No, but look, I think I've got enough from that. And as Mr. Williams says, I think we need to do more than a Google site visit and actually go and visit it. But it seems to me that there at least is an element of public land frontage. The question is whether that pedestrian control should apply to that frontage.
Correct. I think that's the fundamental question. Just and looking at it in terms of, you also have where this applies. So Alicia made the point regarding through the New World site as well, and how that applies is in my view, based on her evidence, is quite novel and quite strange. Yes,
Yeah.
there are some separate retail tenancies here, but also, I'm not sure if you can see my cursor, but also how isolated this is when you look at, say, for instance, down and up and connecting up into the main road. It does seem quite strange from that.
I get that. It would appear from just looking at it on my laptop that it's a different type of environment to, say, Broadway.
Yeah.
So,
yeah, and I think that the point being that you generally have these applying right to the streetscape, and then you have a car park, be it public or private. I wouldn't be able to confirm either at this stage. Between that and the actual Merino Place road, so it is different. Is the only point I'm trying to make here.
okay, thank you.
I've got a question. There is a township plan that was done 2 or 3 years ago, which I think some of this overlay was probably used by staff to form their pedestrian frontages overlay. Have you seen that?
I haven't seen that. My only understanding of the application of this was that it was in the operative plan and it's been copied across identically into the proposed plan. So I wouldn't be able to comment on if council had looked at that, but I certainly haven't.
Are you aware of the what are they called? You know, there's a substantially large employer across the road from the new mill.
Yes, yes, very, very familiar. Been there many times.
And a number of community assets which are heavily used.
Yes, yes, the council. Yes, they're referring to the council offices and the parks down on the side.
Yeah. Okay, thank you.
Right, so I've just had my eureka moment. And yes, I have been to that environment many times. I just didn't tend to look at it.
You would have probably walked across and got lunch at some point, I imagine.
I do.
Yeah.
Okay.
All right.
Again, I still think it justifies us going there again and looking at everything else but the council.
Okay, lunch plans are sorted. Thank you.
Yeah, I know that.
Yeah, why?
So then you're going to ask yourself what's the reason for that.
Yeah. Yeah.
As well, so.
Okay. Have you got anything else either witnesses want to add to your statement?
No, sir, not from me.
Okay, while we have a bit of time, we've been asking officers if they'd like any questions or clarification that I can put to you. So, got the opportunity to put some questions through me if you wish.
I think we've understood what they're trying to tell us.
Yeah, David, I just want to say, like from us on the committee, it's useful to have this discussion with you and Alicia on these matters. I'm not saying that we necessarily agree with what you're saying, but it's useful to have the discussion because it just helps explain your situation more fully and also the council officers more fully. So thanks for taking the trouble that you do and going to those presentations. Thanks.
No problem. Thank you.
Okay. Should we just take it? Should we just go straight into the next one? Okay, so we'll ask you to change your hats now.
Yeah.
You're going to stay in this now, or are we going to? Is this when we say hi to you?
Yes.
Thank you very much.
Thank you.
Okay, bear with me. I'm just going to sort out the situation here. As I indicated earlier on, there is a lot of parallel between the two briefs of evidence. So I will actually skim through this a bit quicker because I feel like the conversation is actually, questions and conversations are very similar. So I'll work my way through it, but I don't anticipate that this is going to take as long as the last. Okay, so here's template again. Can you guys see that? Just double checking. Everyone can see that? Yep. Okay, so very similar zoning frameworks, definitions, and nesting tables, and then the MUS provisions, and then summary and key takeaways. I'm actually going to propose that I skip through this because essentially the point I've made in the McDonald's evidence is the same as in foodstuffs evidence, and I feel that we have canvassed this quite extensively in the last session, so I'm happy to skip through that.
Perhaps I could just ask, I had made a note to ask you a question about the retail activity definition. Are you going to get to that, or is it appropriate?
Yes, that's next, sir. So this again, these are slightly different because McDonald's have actually sought slightly different definitions. So again, they have a point on nesting tables. They support and accept the definition for drive-through facilities being added. I think that's helpful. But then seeking new definitions for retail activity and food and beverage activity, and well, the deletion of large format retail. And I'll come to why I recommend that. I've sort of alluded to it in the last presentation, but in my mind, the definition of retail activity is actually quite a key one. And if you define retail activity, in my opinion, and experience, putting a gross floor area requirement, say for instance 450 square meters in large format retail activity, is actually unhelpful and complicated. In my opinion, the better approach, if you are going to land on a gross floor area requirement based on justification provided as to why it's necessary, then the better way to do that will be to have a definition of retail activity, which describes the activity, and then in the rules within the various zone chapters, put in the applicable, if you want to, GFA requirement. So that, and again, I looked at other examples. In particular, again, I looked at the Whangarei district plan. They have a definition of retail activity, and this is why I referenced the shopping centre zone. The shopping centre zone has a definition of retail activity, and it does have a gross floor area requirement as it applies to the shopping centre zone, but it's in the rule. The actual gross floor area requirement is in the rule. And in my opinion and experience, if you're going to put restrictions on something, it shouldn't be hidden in a definition. It should be in a rule. So that's why I had recommended the definition of retail activity, the deletion of large format retail, and also food and beverage. And the reason I recommended food and beverage activity was because you have it referenced in, for instance, the light industrial zone. There's a provision within there which refers to it, and it's not clear what that is because there's multiple rules. So I thought a definition of food and beverage activity would actually be quite helpful. So I've talked about the nesting tables. I don't propose to go back through that, but those are the definitions that I had recommended were inserted to the plan. So those two, and look, again, that they have under there, they have a nested, and I put those in there as an example. So retail activity means activity selling, exposing, displaying, or offering of goods, merchandise, or equipment for sale or direct hire to the public. And then a point there that if you decided to do it, that definition was included within the commercial activities definition grouping. Likewise with food and beverage, it just quite clearly says premises where the primary business is selling food or beverages for immediate consumption on or off site. It includes restaurants and cafes, food halls and takeaway of food bars, but excludes retail shops and supermarkets. So that, actually, to go to your point, Sir, regarding the inclusion or exclusion list, that actually features in there. I agree that that's an approach that you can use, and it can be quite helpful when you're applying an activity-based rule. So I'm going to pause there and see if you've got any questions specifically on those 2 points.
Yeah, look, I've got a question relating to large format retail, and I sort of try to look at these things as simply as possible in the first instance. And it seems to me that large format retail, by its very nature, has to be of a certain size or bigger. It's defining an activity, type of retail activity, which by its very nature says that you are larger than other retail activities, or what you would normally expect a retail activity to be. And of course, that then gets attached to a whole lot of effects that you try to avoid in terms of maintaining your centre strategy or what have you. So it sort of feels like if you've got an activity which by its very nature is meant to be of a certain scale, then wouldn't a definition help to say, you know, this size? What do you mean by large?
Well, so I've recommended, so it doesn't feature here, but I recommend the deletion of the definition of large format retail, because you're better to just say the retail activity, and then if you're limiting it in a particular zone or environment, so, you know, in this instance, the council is electing to limit 450 square metre retail activities in the mixed use zone, possibly in other zones as well. In my opinion, the activity definition should be the activity, and then it's clearer if you actually have the restriction, if you're going to apply it, in the rule. So the way you would frame this would be retail activity permitted unless you are over X square metres. That to me would be quite consistent with how that's addressed in other areas. So I've mentioned obviously the Whangarei district plan, and then the size is in the rule. So if you're looking at the rule, you know what size you can be or not to be permitted or not.
But over the years, large format retail has become an activity, a type of retail all of its own, and you can go pretty much anywhere. And as long as you're saying large format retail, it's an LFR. If you say, I mean, you can walk into any sort of local authority and say large format retail, and most people have an idea that large format retail means your big buildings and spotlights, and you know, everyone sort of intuitively knows what what that is. But from a planning perspective, we all know that they shouldn't be allowed, they generally shouldn't be encouraged in town centres because it takes away from those other retail functions. You're better to locate them elsewhere, and multiple local authorities have strategies on how to do that so that it doesn't undermine your existing town centres and what have you. So it's to me that you sort of almost need to recognise that large format retail is a thing. Otherwise, potentially, and I'm just playing devil's advocate here, David, and that is just sort of say, well, it's just retail bigger than X under the activity retail. Will that possibly lead to some confusion where people will say, well, okay, I can put my large format retail here in the town centre, as opposed to it, no, we're specifically providing for it in these places.
I take your point there. I think what I'm trying to highlight here, though, as well, is in terms of the mixed use zone, you have this feature and confusing overlap where the 450 square metre limit for an activity has been inserted. I'm just actually going to just quite pivot here and see if I can change it and show you what I'm saying here. Does that come up?
Yep. But,
yeah.
Probably might.
Yes. Yeah, I'll zoom in a little bit. So these are the track changed section 42A recommended provisions. And you have this situation where you have a 450 square metre GFA applying to a number of the permitted activity rules. So they're actually the 450 square metre GFA has been recommended for inclusion, and so this is, for instance, the commercial activity excluding supermarkets. 450 square metres, and then then 4 is discretionary. But the point I'm making there is then you go down to here, and you've got a rule which is large format retail, which is also 450 square metres, but then it's not in the rule. So possibly the answer here is just in how the council has recommended its rules, but you have this situation where you have a 450 square metre limit referenced in provisions and activity-based rules, but then you have a large format retail rule which has a 450 square metre limit, but it's in the definition. So at the moment, we're in this situation where we kind of have both. And in my opinion, observing it and interpreting it is quite confusing and challenging. So it could be an either or. It could be a way that you simplify and rationalise it. But in my opinion, it was clearer to have a definition, and looking at the other example, potential farmland district plan, having a definition of retail activity and then listing the GFA, whatever that is, but be that 450, 500, 600, I think that's one of the questions you have to ask yourself is why is it 450? I don't know at the moment. But those are the questions I've been asking myself and why I've been making some recommendations on this, because I think at the moment it's a little bit confused in the provisions.
It's part of the confusion come from trying to embrace large format retail as part of retail. Maybe large format retail just needs to be set out on its own.
Yeah, so I would absolutely agree with you on that. You'd have retail activity, and then you might have large format retail nested off. But then it'll be very clear when you're looking at the objectives and policies that say reference retail activity, that also refer to large format or not, because it could also say excluding large format retail. But at the moment, you have this fundamental disconnect in terms of activity definitions where it's quite challenging to figure out where you actually sit. And I think part of that is in that you have a definition which has a gross floor area, and then you also have rules and provisions within this chapter which refer to a gross floor area. That's the point in the challenge, what I was grappling with when I was writing this evidence on these matters. I'm just going to go back to the presentation. So, are there any other questions on that before I move on?
No, I think we understand the issue. I think we probably want to contemplate it further and probably ask some questions to council officers later on.
Okay. Yeah. And look, and to take the point though, you could still end up having a definition. I think it's just the consistency and application of it and how you refer to the GFA. Sorry to interrupt you there, sir.
I think Commissioner Stratford has another question for you.
Oh, and I'm not sure your officers that I need this clarified from, but in the section 42A report in point 547A, the officer makes a recommendation on the GFA rule. Are you saying that the in A there, which is I think page 147, that doesn't address your concern?
Can I just catch that number, paragraph number again? Was it 547?
Yeah, that's it.
Yeah. What was oh, so that's relating to the change to MUS Rule 1. So that I didn't disagree with that. I think there was a 300 square metre limit in that. So there's slightly, because what has happened now is you have a 450 square metre repeated across multiple activity rules, was the point I was highlighting earlier.
Thank you.
Okay, I'll carry on.
I just suppose I'm not a planner. I'm one of the councillors on the hearing.
That could be the matter.
Yes. Don't apologise for this. While we're here, I just want to ask another quick question. I think I know the answer, so I'm just really going to clarify. So I'm sort of reading your evidence, and you're advocating for gave us the opinion that you thought a definition of retail activity was required. I thought, why on earth would McDonald's want a definition of retail? But is that because you want a definition of retail and fast and food and beverage and other things? It's really to slice and dice the various activities, of which food and beverage is one of those. Would that be why you've done that?
Yeah, it's simply, so McDonald's does have a food point on requesting a submission point on requesting a definition for retail activity, and it's all purely about and comes down to the application of the rules and provisions. It clearly wants to know, so McDonald's as a submitter wants to know where its activity sits, because ultimately, in McDonald's experience, but more so in my experience working on behalf of them and consenting, it fits multiple things. It's a commercial activity, it's a retail activity, it's a food and beverage, but it's also a drive-through facility. So having clear definitions and provisions for that is helpful from their perspective, because they know what consents they require. And from a planning perspective, this is my professional opinion, it is useful to be very clear what is what and what you're referring to. That's essentially the point I'm making in my evidence is on that. And I think at the moment, it's not very clear.
Okay, no, thank you. Let's clarify that.
Okay. Again, I feel like we've probably talked through this. I think I might just come to this point. I've taken it out actually. Look, I've talked through the 450 square metre requirement, and I think we've probably covered that quite effectively. The same regarding the GFA triggers and then the restricted discretionary activity requirements. So there was the link to the matters of discretion, so transport, signage, landscaping, noise and lighting. So again, I'll just make the general point that I think there are provisions in there that manage those effectively if you're going to have a restricted discretionary activity trigger. So I will not repeat that, because I feel like I've canvassed that pretty effectively in the last presentation. My recommendations. Yeah, that's the same. It's the same for drive-through. So again, the justifications provided. We need this to manage the impacts. The one thing I did pick up post my reviewing my evidence was one thing that might be actually quite valid here is hours of operation. Now, I didn't address this in my evidence, but I'll say it now, is that, in a mixed-use zone, it could be, if you did need to have a specific control, within hours of operation is one that you would generally apply to, say, a drive-through facility. And it's on the basis that if you don't, and it led to them operating 24/7, there can be effects, especially if you've got residential activities. So that was an oversight in my evidence, which I didn't pick up. And I think there may be some benefit in reporting officer council response also saying, well, if hours of operation are the concern that is not controlled by the existing provisions, then possibly including some reasonable hours of operation is a good control. And I'd say McDonald's would probably say they want to be 24/7, but that's my professional opinion. I think you do have a obligation in an environment where there are sensitive activities to consider whether the hours of operation is a control. And that could, for instance, align with what's in the daytime noise limits, which I think are 7 o'clock till 10 o'clock at night. Don't quote me on that, but something like that might be reasonable. That was just something I picked up reviewing my evidence earlier today. Yeah, so look, I just highlighted this similar to the table I had for supermarkets, and it's just saying that they're actually the matters of discretion I think are identical between the two, and it's just highlighting that we actually already have these standards. And then the noise and light, again, I just highlight that there is the noise and light provisions in the chapter, which are effective in my view and have necessary triggers for consenting. The only outstanding matter, as I mentioned, was the hours of operation. So that was my recommendation there. I think you could end up in a situation, as I say, that you had a hours of operation control that applied as a permitted activity provision. I'm just going to quickly sum up. So talked about the zoning framework, also in this foodstuffs presentation. Talked around the 450 square metre GFA and definitions, and also the provisions in the mixed use zone for drive-through facilities as well. So I'm going to stop there and see if there's any further questions or comments.
I don't have any questions on that. I'm going to take the opportunity to ask a question about narco generation when we finish this all. So.
No, I don't think I have any further questions. Again, I understood your evidence on this last bit, and I'm probably going to put some questions to council officers later on that basis. But I haven't got any further questions for you. But I'll let council, see if council wants to take the opportunity to ask a question of clarification.
No, but I think, yes, I will have to defer, obviously, to Mr. to want some questions. Just to clarify that Mr. Adams recommended changes to drive-through. We have a copy of that, furnished with that, recommendations, if I heard correctly.
Yes, that cut in the slide, just to answer your question there, is attached to my evidence. The only addition which I haven't put in there was, again, that suggestion that hours of operation could be a beneficial and useful control to include. But I don't have that actually written down anywhere. That was more just me.
That updated as submitted formally, that would be helpful.
Yeah, so the request is, and I think it's a clear one, update your evidence, please, to clarify.
Okay, yep, I can do that. I think it would be quite simple. I'll just email it through with an updated recommendation on hours of operation.
And that's then recorded as opposed to something that we have to go back and potentially check the audio on. So I think that's
yes, no, absolutely. I'm happy to do that.
Are there any other questions? Okay. Well, it looks like there is no further comments. Yeah. So now, Commissioner Watson wants to ask questions about evidence you wrote, but said you didn't want to, but your client didn't want to.
Is this in relation to NAFA generation? Yes. Yeah.
Would your client be happy for us to put some questions to you because you're here? Would they be? Are you happy to answer questions on that, given that you're here, recognising that they said they didn't need to appear?
Look, my duty is to assist you guys as a panel in making your decisions. So I'm happy to answer any questions you've got. And I think I did. So these are the letters we've tabled for submitters where they've decided they do not want to present expert evidence and have a hearing. But I'm happy to take any questions if you have them.
McDonald's are happy to pick up the tab.
I'm sure I'll find someone.
I get to charge another hour at a time. Hey, look, it only relates to the NAFA generation limited one, and it's a letter. It's not actually, you're quite right, it's not a statement of evidence at all. It's just a letter. Never are. But it just talks about having been involved with the decisions around hearing 11. Sure, probably should be clear on it. But you talk about the new definition of light industrial activities. It's your final bullet point in the letter.
Yes.
Which I've highlighted. And you talk about the inclusion within the definition of, and I quote, construction, operation, and maintenance of structures associated with renewable energy generation. You're supportive of what the office has got to say and not including that, but you still make the point that you'd like to have it in. So do you want to add anything to that?
Yeah, so correct. This is written just on behalf of NAFA Generation to, I guess, reaffirm their position. It's not my expert evidence. I think it's important to highlight. This point has a reflection in terms of the findings in the renewable energy topic and hearing. So why I would link you back to that is because there's a recommendation from the reporting officer for that topic that in industrial zones there is a consent requirement for renewable energy activities. I'm sort of going based off memory here. And so in that case, in that hearing, Top Energy, and to be clear, NAFA Generation is a subsidiary of Top Energy. Top Energy made the point that actually renewable energy activities, e.g. solar farms, should be permitted in industrial zones. And that definition there links to that. So there is a recommendation currently before you that you should trigger, again, as I understand it, a discretionary consent if you're in an industrial zone. From my expert opinion, I don't agree with that. Industrial zones are used throughout the country, so light industrial zones, for renewable electricity energy generation. And why that is particularly pertinent for NAFA Generation is they have some of their land currently zoned, well, under the operative plan, zoned industrial. Some of that, not all of it, carried forward into the proposed plan. And they have existing and future planned renewable generation activities within that site. So, for instance, the geothermal activity. So this is essentially NAFA Generation highlighting that point as well. We have got activities here. Are they part of the industrial activity definition? But also there's another way that could be addressed, in my opinion, which would be in the renewable energy chapter itself. So hopefully that makes sense.
So is your concern just around the NAFA site itself, or more widely on a wider basis?
So NAFA Generation, their concern will be for the NAFA Generation site. My concern is broader than that. I have been involved in a number of solar farms around the country. I have recently consented one in Whangarei in Ruakaka, and it's in a light industrial zone piece of land. And in my view, and this is the point that I made in hearing 11, I think that's the hearing which was infrastructure and renewable energy. I made the point that renewable energy resources don't follow lines on a map or zones. They are where they are based on a number of factors. But for instance, for solar, it's based on topography, it's based on where everything lies, solar variability and things like that. So in my opinion, if I'm looking at it from my opinion, I don't agree with having a discretionary consenting requirement based on activity in an industrial zone for renewable energy, in particular the light industry. You could make an argument heavy industry is a bit different, but especially for light industrial zone.
That's helpful, thanks. Thank you.
Thank you.
Okay, well, I think we any clarification questions out of that.
Yeah, I think we would struggle to meet the demand more broadly in light industrial zones that we set out in our HPA if we are talking about hectares and hectares of solar farms. So, for example, I think there's a conflict there between two highland directives, in my view, potentially achieving those.
Yeah, so
Huge.
there is a current NES for renewable energy, is that correct?
NPS.
NPS.
Yes, NPS.
And how old is that? When was that released?
That's the first one, Mr. Chair, from my recollection.
Very old.
Yeah, so it's very old and it's written in
2011.
very different. Might have been earlier than that, 2008.
Right. Isn't it? Is an NES coming?
So the government has obviously released its 4 packages of national direction, and there is quite a lot of significant new direction around renewable energy. would not be able to tell you specifically whether that includes an NES at the moment, but I know that there is an NES, for instance, for electricity transmission as well. So there is a lot of change, and the government has been quite directive on renewable energy targets and its feature in the new national direction and the replacement of the RMA.
Yeah, because sort of national direction on that particular issue, Mr. Willen, would be helpful. About, but also too is that I've seen examples where a solar farm was proposed on Class 1 highly productive land, and a local authority opposed that, saying, well, you, and then the applicant demonstrated that they could graze sheep at high ratios around solar panels because the grass grew better. That's the shade it provided in the summer. So, but the other thing too is that, but these things all need to be wrestled with, I think, because solar farms are large in area. You finite resources in terms of industrial land, and people are already nibbling at industrial land for a number of reasons. And so that question of where should solar farms be located in terms of its zoning seems like quite an important one and something that should be approached from the national direction.
I guess the light industrial zone is one that's generally intended to be reticulated. And reticulation infrastructure is at this stage, particularly in our district, very valuable in terms of any existing capacity that we have. So in my view, case by case, in terms of a broader assessment, there's my recollection is that there's some proposal, and correct me, David, there's a rezoning request for one of your clients that might relate to that. It might be, at least on a site-specific basis, deal with that matter in another venue or one.
Correct. So actually NAFA Generation Limited has got a rezoning request as it applies to their land. So they have got existing operative industrial zoning on part of the site. In their submission, they sought a larger area, but they've actually stepped back from that, and they've just said they want to retain the operative zoning that they've got. Essentially, the plan is proposed to downzone that from industrial, light industrial, to rural production, and their rezoning request, which I have circulated some evidence on, I think this will be here in 15C, does address that point, and it's all linked into NAFA Generation's existing and future operations there, based on, again, not solar, but solar could be a feature eventually, but they have got obviously the geothermal power station and existing power stations as well.
Yeah, it's an interesting issue for us to wrestle with. What is the ideal zoning for large-scale solar power regeneration activities? It sort of suggests a rural location.
Yeah, look, I think some insight into, both myself and Ms. Vista had some really commendable discussions with MUB on identification of suitable sites and locations for renewable energy generation, and the government at that stage was looking at considering renewable energy zones or having council identify areas where renewable energy may be more appropriate. And I don't know whether that's moved on. Our feedback was certainly that we won't necessarily know what factors as a local authority, and actually it's perhaps better done at a higher level, that sort of work. But I would say that it's potentially in the works of somewhere or someone to do. So it's been spoken about, but I haven't followed that any further in recent times.
And I'm at best peripherally aware of these issues, but there's also some discussion going on about, is it flatland better, or it's slightly north-facing, slightly sloping north-facing land better? And I suspect there is an answer to these things.
Yeah. I mean, my understanding, sir, not with respect to Mr. Adams' clients, and my experience outside of this region, is that there are matters driving certain types of renewable energy generation that aren't necessarily commercial in nature, but there's a lot of other factors that are driving significant investment. So, but we do have, yes, at the station national direction and some numbers to hit. The government has indicated that continuing to go towards those. So, yeah, there's a lot in the mix and there's a lot of uncertainty.
It's a difficult one to sort of run into the plan because of the site-specific nature of renewable energy activities. You know, to put it in a particular zone is really the antithesis of what
And I think,
it's all about.
well, I think in the Waikato, we do have specific zones set aside for hydro generation, for example. So those activities can be recognised specifically for their activity. Obviously, there's something a little bit more certain and specific about a hydro dam that ain't going to move, and the issues are probably fairly narrow. But there is precedent for specific zones for that. Again, I would suggest that possibly specific to the type of generation, and that, you know, I think, you know, for example, you might retain a rural production zone under a wind farm, for example. So different nature of the generation activities. But I have heard similar arguments around the sheep discussion, the productivity of sheep based on Australian experience and Australian example. I'm not aware at this stage of any New Zealand.
There's one in South Auckland. And it was on Class 1 highly productive land, and Auckland Council was opposed to it because it said that it was not using highly productive land. Of course, if NPSHPL doesn't say you have to use it for a highly productive purpose, you have to avoid removing it. And so solar panels can sit on Class 1, 2 or 3 land and be removed and not damage the soil.
Yeah,
and then they said, "Oh, we'll graze it." And they said, "Well, you're not using it intensely enough." And there's nothing in the HPL that says you can't run sheep on your highly productive land if you choose to do so. And then they ran off and did a whole lot of work and came back and said, actually, it actually helps, and particularly in summer because the grass grows. So,
and also water diversion as well as a key focus of this. So the example I gave you in Ruakaka, they will be grazing underneath it. It's on a farm site. It's not highly productive.
We want grass to be grazed. We want the grass to stay low. We don't want it growing over the panels. There is a broader question, which is you still are taking away highly productive land from being used for highly productive purposes, albeit on for a limited timescale.
In a practical sense, Mr. Chair, what happens is there is investment to connect into the grid, which costs money, and the value of the land is no longer based on the use of the land as production land. That reflects some of the investment and higher level of potential income. So while it doesn't in theory remove it, in a practical sense, the capital investment on it does.
Well, and in that sense, the capital investment is not that high. And
certainly the return.
The return in spot prices can be quite good. Okay. Well, that's an interesting discussion. We're happy to sort of go there because we've got the time. Thank you very much, Mr. Madam, for your evidence again. I'm sure we will see you again very shortly in one or more of 15 hearings.
Yes, it's a marathon.
DC and D, I suspect. But yep, we're putting up pace and sprinting to the finish line.
Awesome. Okay, thank you for your time. And we'll be in touch regarding the drive-through facilities matter.
Thank you. Thank you.
Ka kite anō.
I should disclose that I am a small-scale electricity provider because I've solar panels in my house at home and feed back into the network and earn a huge 17 cents a kilowatt.
Wow.
I'm sure that $8 a month is well worth it.
Well, the thing is that during summer, my power bill goes into credit up to about $300, and then gets wiped out in the first week of June.
Hey, we're on break.
I think we'll just take a break. We'll just take the morning tea break, and then we'll come back and just see what we want to do.
Okay, stopping the recording.